Okay, we've still got some people joining, but let's get going. Welcome to everyone to the October episode of Outline. My name is Trevor Ivory, and I'm the UK Head of Planning for DLA Piper. I'm joined today by two of my colleagues and stars of the planning team, our legal directors, Amy Truman and Ian Graves. And today we're going to take a trip to Diddley Squat in the Cotswolds. And I'm sure many of you, as me, were slightly unnervingly gripped by the saga that's been Jeremy Clarkson's attempt to dabble in the world of farming, and it's been interesting to me to watch the unstoppable force that is Clarkson hitting the immovable object that is the town and country planning system, and in particular, for those of you that have seen it, the issues that he's had with the Diddley Squat farm shop that he built back in the first lockdown, and which is subject to a condition that seeks to restrict the goods he could sell from the farm shop to local goods that had been produced within the local authority's administrative boundary. But it isn't just on primetime television that planning conditions have been an issue, and sometimes I think planning conditions can be perhaps the poor man of the planning system. Local authorities are often very keen to impose them, but they don't always get the scrutiny that they deserve in terms of how they're drafted. And certainly, I would suggest that sometimes, no sooner has the planning permission been granted, the planning conditions get ignored and everybody moves on as if they weren't really there in the first place. But that changes when things go wrong, and suddenly the planning conditions then become that much more important. And I think we've seen that not just on Clarkson's farm, but we've also seen it recently in a run of cases that have come before the courts in the last couple of years that have looked at some of the tricky issues around planning conditions and have highlighted some of the reasons why planning conditions perhaps need a little bit more care and attention than we generally give them. So what we want to do today is to explore some of those cases, look at some of the lessons that we should take away from those cases, and also we'll have a look along the way at Mr. Clarkson's issues down on Diddley Squat Farm. For those of you that are watching the live broadcast today, we will circulate a list of the cases that we refer to with the email that comes out after the event. If you're watching on our YouTube channel, then we've posted the details of the cases and the references in the commentary, so you can check those out at your leisure. But let's get underway. And Amy and Ian, thanks for coming on today. Can we start by just looking at the scope of the legislation? As ever with planning, you've got to go back to the original legislation to understand where these things start. And it's Section 72 of the Town and Country Planning Act 1990 that gives planning authorities the power to impose conditions, doesn't it? So, Amy, could you perhaps just get us going by giving us a brief summary of what Section 72 says?
Yeah, sure. So I just wrote it back a little bit and started with Section 70, which allows planning permission to be granted either unconditionally or subject to conditions as seen to be fit. And then Section 72, as Trevor's just mentioned, provides the power to impose the conditions. That power is also quite wide. So the conditions that can be imposed are to either regulate development or use of any land that is in the control of the applicant. It can require works to be carried out on any of this land as far as it appears to be expedient for the purpose or in connection with development which the permission relates to. So that seems quite broad. It can also require the removal of buildings authorised by the permission or the discontinuation of the use of any land at the end of a specified period, and works for reinstatement of the land to be undertaken. So I guess their minerals permissions spring to mind of how their conditions would fit in with Section 72. Ian, I think there's Grampian conditions which sort of don't, on the face of it, seem to fit quite with this Section 72.
Yeah, that's right, Amy. I mean, I suppose one of the points here is, Section 72 appears to be quite wide, as you say, but there is a restriction in there, which is that the condition has to relate to land that's within the control of the applicant. I mean, obviously development doesn't only relate to the, or doesn't only impact the site on which it takes place. So that sort of part of the legislation could, in theory, cause some issues for lots of developments. And so that's something that's been considered by the courts in the past in a case called Grampian, as you say. And I mean, lots of people viewing this, if they're familiar with the planning system, are going to be will have heard of Grampian conditions before. And effectively, in the case of Grampian, what the court did was it considered the distinction between a positive condition, a positively worded condition that required the developer to bring something, some particular set of circumstances about, and a negatively worded condition which just said that the development couldn't commence until a certain thing had happened. And what the court said is that that sort of negatively worded condition was okay. So what this would allow the local planning authority to do is to say that the development couldn't commence until some other situation had arisen, and that could be off the site. And so I suppose, if you're familiar with looking at planning application documents, the reason that the council is always concerned to have the sort of the blue line on the plan as well as the red line is because that shows the land that's within the control of the applicant. And so it knows whether when it wants to impose a condition, it needs to impose a sort of a regular condition, which can be positively worded, or a Grampian condition, which can be negatively worded. So, I mean, they're Grampian conditions. They're really widely used. I think that the case was back in the 1980s. So, we're sort of getting on for 40 years now of the use of those conditions, and they're really helpful in terms of sort of controlling development and allowing development that to go ahead that might otherwise be refused.
It always seems to be Grampian is one of those places that is no longer a place if you work within the planning system. It's a concept. It's up there with Wednesbury, isn't it? In that sense. But I think for me that clearly we're dealing with quite a wide power. Section 72, Amy, as you say, is pretty wide to start with, and Grampian gives us that ability to take it further, take it beyond the land that is within the applicant's control. So it is a wide power, but it's not limitless, and there are limits on its use, and I think everybody involved with the planning system knows you cannot require a transfer of land or a payment of money via a condition, and indeed that's why we have Section 106 is in order to deal with those sorts of issues that can't be done by condition. But there was an interesting case recently, the DB Symmetry case, which was looking at other restrictions, and in particular in that case the local authority was looking to I think to interpret a planning condition in order to argue that it required the owner of the land to dedicate some of that land as public highway. I think the court's consideration at that point was quite interesting, I think, Ian, wasn't it?
Yeah, that's right. I mean, so the DB Symmetry case related to an employment site, and one of the conditions that the council had imposed in that case required that the access road, so those sort of internal roads in the employment site, had to be constructed in such a way that each unit within the estate would be served by functional highway. And there was a disagreement effectively between the developer and the council as to what that meant. What the council said was that it meant that the roads had to be dedicated by the developer as highway, and the developer disagreed, made an application for a certificate of lawfulness to try and establish the point that these roads, although the developer said they had to be constructed in a way that would be suitable for use as highway, they could actually be used as sort of private roads, and they ended up in an appeal situation, and the inspector on appeal agreed with them that all the condition meant is that the road should be capable of functioning as highway in the sense that they had to be constructed to adoptable standards and so on. When the case was considered in the High Court agreed with the inspector and said that this sort of condition, so that required a developer to dedicate land as highway without compensation, would be unlawful. But effectively, what the court was saying is, in these sort of circumstances, there's no real difference between requiring dedication of land as highway and actually, simply requiring the developer to transfer the land, because the consequences for the developer would be effectively the same.
It seems to me, reading that case here, it sort of looks at that idea as well of the condition effectively being used to try and usurp an existing statutory regime. But for the condition, the landowner would have had certain rights, whether under the Highways Act or if the land was being compulsory acquired, they'd have had rights potentially to compensation or to be involved in that process in different ways. That seemed to be quite an important part of the rationale of the court there in saying you can't usurp that statutory regime, didn't it?
Yeah, that's absolutely right. I mean, one of the things that the court considered was, if the council wanted the land to be dedicated as highway, it had powers under the Highways Act, as you say, to sort of acquire the land compulsorily for those purposes. Now, obviously, if it were to take that route, the developer would have had various rights. There was a statutory process that had to be gone through by the council. The council would have had to satisfy the Secretary of State that there was a compelling case in the public interest for the land to be acquired. And ultimately, if it could make out that case, the developer would have been entitled to compensation in accordance with the statutory regime. So, I mean, effectively what the court said was that, to impose a condition that sort of achieved that end, if you like, would be to sort of misuse the power to impose conditions under the Planning Act to achieve sort of an object that was actually addressed by other statutory powers. So, in this case, as I say, under the Highways Act.
So sort of putting all that together, we can't require transfers of land, we can't require payments of money under condition, we also can't sort of usurp other statutory regimes. But you do, increasingly, I think, see conditions that are requiring submission and agreement of schemes, and then ultimately compliance with those schemes, perhaps an open space or an affordable housing scheme on a residential consent. And quite often, an inevitable part of those schemes is going to be a payment of money or a transfer of land somewhere along the line. How do we reconcile that with the case law and those limits on the scope of Section 72?
I think you can start by using a Grampian condition to assist with these. So you'd require the scheme, but have a negative condition that you can't start development until the scheme had been provided. There's some support for that in the PPG and also in some recent cases that have come forward that we've seen going through appeal that basically allow you to do this, to use a Grampian condition to require the scheme, and the scheme itself can be a payment of money, or you can even require a Section 106 agreement to be entered into before development commences. With the latter, I think you would have to have exceptional circumstances to be able to use that, but it is still a possibility. And that sort of gets around the fact that under condition you can't require a financial payment or require something to be given or provided, say affordable housing or something.
Yeah. The 106 point is a really good one, I think, Amy. We literally, on my desk this week, I've been having that debate with a local authority as to whether you can have a condition that requires a 106, and it comes up quite a bit actually, because you find situations where perhaps the landowner doesn't have complete control of the site, or there are other interests that you can't get bound into the 106 at the point that you're trying to secure the planning permission, and so you do have to look at a condition. And it's interesting that the local authority that I'm dealing with at the moment was quite sceptical about the ability to do that, although in the end they did go off to council, and council did agree with us that it is something you can do if you take that Grampian style. So that was 1-0 to DLA Piper, which was good. I think there's sort of another case that probably worth just flagging up in passing as we're talking about scope, in partly because it's a Supreme Court judgment, therefore it's always particularly important and pertinent. But that's the case of Wright back in 2019, and the case was essentially dealing with the question of what is capable of being a material consideration in the planning process more generally. And one of the parties to that case was inviting the Supreme Court to effectively amend the well-established Newbery principles coming from the 1981 Newbery case. The court declined to do that. The Supreme Court said no. They were quite happy that the Newbery principles were as relevant and appropriate today as they have been in the past. But in the process of that, there was an issue with a condition that was linked to the substance of the material consideration debate, and the court made the point, and it's perhaps an obvious point, but it's worth saying given that the Supreme Court felt the need to say it. They made the obvious point that you can only have a lawful condition if the condition relates to a material consideration. If the thing that the condition is trying to deal with is not of itself capable of being a material consideration, then the Supreme Court was pretty clear that by definition that condition must be unlawful. So I think it's worth keeping that in mind. And I suppose the other thing we ought to say on restrictions to the scope of Section 72 is there's not just the legal restrictions, there are also policy restrictions as well. And certainly in England, it's currently paragraph 56 of the framework that sets out the well-known tests for conditions, and there are similar, if not exactly the same tests across the other devolved administrations. It's worth keeping in mind that that isn't a legal restriction, but in policy terms, if you are trying to impose a condition as a planning authority, certainly if you were having that debate in front of a planning inspector, the inspector would expect you to be able to demonstrate that those policy tests were satisfied. Otherwise, regardless of its legal status, you're not going to get that condition. But let's move on from scope perhaps and look at the bigger issue maybe of interpretation and how you actually go about interpreting conditions. As I said at the beginning, they tend not to be drafted by lawyers, and so they're not legally drafted, and as a result they're not always as clear perhaps as they could be. So the question of how you interpret conditions is probably the one that we deal with most in this area. There are some established principles on that from some of the older case law. One important read for anyone wrestling with this issue is the Hume case in the Court of Appeal back in 2011, and that set out some what have now become quite well-established principles on how you go about interpreting a condition. The one thing I'd say, if anybody is reading Hume, is you need to treat with caution the Court of Appeal's view that you can't, under any circumstances, imply a condition to a planning permission. I think there's been case law since that suggests that might not be quite as absolute as that judgment says. But the other principles that are espoused have been quoted with approval many times in the court. So it is sort of a good place to start. The other case is not a planning case at all. Actually, it's a case concerning a condition on a consent issued under the Electricity Act, but it is the somewhat infamous case in the Supreme Court back in 2015 that involved none other than the former president of the United States himself. It was the Trump case up in Scotland, and whilst it wasn't dealing with planning, it dealt with the approach that should be taken to the interpretation of conditions generally, and the Supreme Court did consider planning conditions as part of that. And the point the Supreme Court made is there is no magic to interpreting a condition. The ordinary legal rules of interpretation apply to conditions in the same way as they would apply to any document, whether it's a private contract or anything else. So we know that there isn't special status given to conditions. We have to apply the general law on interpretation. But sort of bringing it more up to date, we've seen, as I said a while back, we've seen a run of cases over the last couple of years that have looked at interpretation of conditions. And in fact, actually, we probably ought to start by going back to the DB symmetry case that you were talking about earlier, because one of the other points in that case was a question on how to interpret that condition, wasn't it?
Yeah, that's right. I mean, one of the first thing, obviously, the course had to consider was exactly how the words of the condition should be interpreted. And as you say, it's a sort of common task of any planning lawyer these days is to advise on how particular conditions should be interpreted. I mean, in DB symmetry, there's quite an interesting discussion of this point, and a pretty good sort of summary of the state of the law. So it's worth a read of that section of the judgment in particular. And the court held exactly as you've just said. There's no sort of special rules in terms of how you interpret a planning permission. And actually, we just deal with it in exactly the same way as we would any other legal document. So what the court effectively said is it used a sort of a reasonable reader test, if you like. What would a reasonable reader understand the condition to mean when read in context of the permission as a whole, and including all the other conditions of the permission. And sort of made the point that it often is important to read the other surrounding conditions, as those can really sort of shed light on how the particular condition that you're concerned with should be interpreted. And that's an objective exercise. So what the court said is that they'll have regard to the first off the ordinary natural reading, or the ordinary natural meaning rather of the words that are used, the overall purpose of the permission. So what is the development for? Any other conditions, as I say, and common sense was flagged as an important aid to interpretation. So imagine that.
Common sense in the planning system. What a radical idea. I think for me, the other thing that came out of it is the court there had those two possible interpretations. One was you must dedicate this as highway, and the other was you don't need to dedicate it as highway. And I think what was interesting was part of the court's rationale, I think, Ian, was that they said, well, we concluded that if it requires the dedication of highway, then it is unlawful. And at that point, probably the court was of the view it was going to need to quash the permission because it couldn't split the condition off from the principle of the planning permission being granted. And on the other hand, they had a reasonable reader could interpret it as saying you don't need to dedicate as highway. And I think part of their thought process seemed to me to be, if you've got two options, one of which means that the whole thing is void and unlawful, and another option that is reasonable and makes sense and is common sense, that maintains the integrity of the permission, then almost by definition you pick the second, rather than picking the definition that leads to the quashing of the permission. I thought that was quite an important, again, bit of common sense, perhaps.
Yeah, I mean that's absolutely right. I mean that approach has been sort of considered by the courts in a number of cases. So I mean, for example, in the Grampian case that we discussed earlier, one of the points that the court was considering was whether if it found a condition unlawful, that meant that the whole permission would fall, and it concluded that it would do. So in other cases that have considered interpretation of permission since then, one of the sort of aids to construction that the courts have used is that. So almost a sort of reductio ad absurdum type argument as to whether if this meant that the condition was unlawful, well that was a good reason not to interpret the condition in that way.
I'm tempted to impose a fine for the use of Latin, but that's a first warning. Well, I'll let you off. So, Amy, rescue us from Ian and his Latin. The Patel case was another interesting one, wasn't it? What does that tell us?
It was really interesting, and just listening to what you guys have been saying about the DB Schenker case, symmetry case. Sorry, I think it's just really interesting how this reasonable reader, natural words and meanings of the conditions that are trying to be interpreted is stamped all over all of these cases. And the point of not reading anything extra in, to me, there's earlier case law that talks about benevolence when you're interpreting conditions. So they try and move away from that because which side are you going to be benevolent to? But I think there is some benevolence coming through on these decisions, and that's certainly what I thought in the Patel decision. So the Patel is about noise, a condition about noise insulation. It was for a development that had commercial on the bottom and residential above, and the argument was whether the noise insulation soundproofing required was to protect the new residential part of the development from the commercial sound, or whether it was to protect against external sounds. But the external use that was noisy, that everyone was more concerned about, was introduced after the permission. So at the time when the permission was granted, nobody had that in their minds. And so that is one thing that came out of the decision, that actually looking at external evidence that has come up since the permission was granted, it's not relevant, because that condition was set obviously when the permission was granted itself and not later on. So really that evidence was irrelevant to reading the condition, which, you know, that just seems fairly plain, simple, obvious really, and I think benevolent. So I'm going to take that word, even though we've tried to go against it. So that is really what that case had to say. Reasonableness.
Sort of it feels to me that kind of comes back to the right case and the point that it's got to be a material consideration. And yeah, it seems to me it would, had you tried to impose a condition to soundproof against something that didn't yet exist, and didn't already have the benefit of a planning permission or something, then you'd get short shrift at that point. It's not a material consideration. The planning system is not expected to be psychic. It's expected to be many things, but not necessarily psychic. So it feels as if that you're right. It is that sort of common sense approach.
Yeah, and to any of the sort of the case law on implied terms and can you read anything extra in? I think, yeah, let's not try and read something extra in, because the world around the original permission has moved on. Yeah.
So, well,
have to be careful.
And Ian, I'm going to come to you in
reading into something.
Sorry, Amy, didn't mean to speak across you. Ian, I'm going to come to you in the Skelmersdale case in a minute, but actually, Amy, you've just used the word implied term. One of the questions I had for you was around the Dunnett case. So let's deal with that one now while implied terms are in your head, because I think what the Dunnett case was looking at was something a little bit different, wasn't it? Which was the question of, can you imply words into a condition in order to make them work?
Yeah, so these two cases, it sort of diverge on this, in that the Patel we didn't want to read in. It didn't make sense to read in. But on the Dunnett, it does make sense to have a slight reading in. So Dunnett was about a condition which tried to aim to stop any use other than, I think it was a specific bee use. And so, but it didn't explicitly exclude GPDO. It just said that no express planning permission could be granted for any, or could be had for with, they couldn't use it for any other purpose without getting express planning permission. And then there was a discussion over whether the GPDO would grant an express planning permission and therefore should almost be read into that condition or not. So could you use the GPDO or not? Was the condition also saying no GPDO? And it was decided that it was, because it made no sense to have a permission which limited the use to the bee use unless it was also trying to exclude the GPDO. So in effect, we are reading in there, we are implying an extra little caveat when we read in. So quite interesting on a, no, you can't imply terms, but you can a little bit on how you're reading it. And that also goes back to a reasonable reader test, because reasonably, why would you have that condition other than to exclude the GPDO?
A fair point, although that unhelpfulness of reading these decisions, you get something. One going slightly in one direction, one going in the other, and the challenge is trying to work out how that's going to apply in a particular case, isn't it?
Yeah.
Ian, I think the Skelmersdale case. Sorry, Amy. It does, doesn't it? It does seem obvious. So I think we've got one more case on interpretation of the Skelmersdale case. Ian, what was that looking at? What does it tell us about how to interpret conditions?
Yeah, so I mean, this was a case about Skelmersdale Town Centre. I was quite interested to read this case. Actually, I'd forgotten about this. In about 1995, I did my work experience in Skelmersdale. I used to go out to the town centre on my lunch break, and it did need some attention. And the council subsequently decided that that it needed to be regenerated effectively. So when the planning application came forward and was approved by the council, it included a condition that was effectively aimed at sort of securing the presence of the key retailers who were taking part in the scheme. And the way that it did that was that the condition required, in order for a retailer to occupy the development, they had to submit a scheme that committed to retaining their presence in the long term. So it was over a 5-year period. And what the Skelmersdale case was about was the sort of interpretation of that condition, and what was meant by the phrase "commit to retaining their presence." And the court effectively, it applied the same sort of reasonable reader test that we've been discussing previously. So what the court did was, it said, well, what would a reasonable reader, what would ordinary person approaching this document understand those words to mean when taken in the context of the permission as a whole? And effectively, it said, well, look, commits obviously connotes some sort of legally binding commitment. And so, there needed to be a contractual commitment in place. So that was the way the court approached that particular question.
Often it's always best practice, isn't it, to make sure that there's a condition requiring a scheme to be agreed, but then a condition requiring that you actually comply with that scheme. And I think this was a lucky escape, perhaps, for the authority, wasn't it, in not having had that sort of extra condition that says, and you will do it once you've agreed what it is. It kind of let them off the hook, but I would say best practice would always be to make sure you're very clear that you've got to deliver and comply with the scheme as well as actually putting it in place. But that word commit seems to have been their escape route, didn't it?
I think that's right. Although I think if you read the judgment, I think that it's clear that the court is right, because that's, I mean, what else would commit mean in this context? But I mean, always if you're a local planning authority, you're drafting conditions, it's absolute standard practice, best practice, as you say, to have a sort of a condition that a partner condition, if you like, that requires compliance with whatever scheme has been approved, because it just cuts out any argument in the future, and any sort of clever lawyers, if I might say, trying to argue that that there's no there's no requirement to comply. Clever
lawyers, I think we should probably leave that there.
We would never do that. We would never do.
We would never do that. Never do that. Not at all, unless it were in our client's best interest, of course. So we've dealt with interpretation. So perhaps it's time to go back to the Cotswolds, and let's see where we get to then with Diddley Squat, because the issue, I think, Amy, was this condition trying to restrict to local produce that could be sold, and it seems to me it's fairly self-evident that a condition on what's effectively a retail development nowhere near a town centre in a remote, isolated part of the countryside, presumably. It seems to me it's well within the scope of Section 72 for a condition to be imposed that says, actually, this is being granted for particular exceptional reasons. Therefore, we don't want it to just become a supermarket or any other kind of shop. That feels to me as if it's well within that scope of Section 72, doesn't it?
Yeah, I think so. I mean, it's a restriction on the use, isn't it? It's just for defining down the retail use. So I think it fits squarely within Section 72. I also think it's this example of the right case you mentioned earlier, in that it was a material consideration. It's a condition. Two things go hand in hand. So yeah, it makes sense to me.
But of course, that wouldn't have made for great television, would it? If it had been that simple. So whilst in principle you can have that sort of condition, there were some issues with the interpretation of the original condition, I think, Ian. What were the issues, and how ultimately did Clarkson's planning consultant and the planning authority resolve it?
Yeah, I mean, there were some issues. I mean, it's interesting actually, because you mentioned earlier on the point about conditions and drafting of conditions, and it often is the condition that is maybe a little bit non-standard that sort of raises these kind of issues. And so the condition in question here limited the products that could be sold to those that were from local producers. But the way that the condition had been sort of framed was slightly unusual, in the sense that there was the condition and the reason for imposing the condition, and then at the end of this, there was a sort of a little NB, and someone had obviously, as an afterthought, realised that local producers wasn't very clear, and had sort of attempted to define that by in this NB by saying that local producers means a producer that's within the local authority boundary. So that obviously created a number of issues around interpretation. I mean, in particular point is whether an NB in that sort of form actually forms part of the condition, or what. I mean, is it a sort of an informative? Does it actually affect the way that we interpret local producers? It's certainly intended to, but it wasn't clear what the legal effect of that condition would be. And so, from both the local authority and the applicant's point of view, there were real questions there about the enforceability of that condition, and just a real question of uncertainty. I mean, obviously, from the operator's point of view, they've got to know very clearly, where they can source their produce from without being in breach of the planning condition, because ultimately, they're on pain of sort of criminal prosecution if there is an enforcement notice and so on and so forth. So, it was a real problem for them. Now, the way that this was eventually addressed is by the use of Section 73, which is the power in the Planning Act which allows permission to be issued without compliance with a previous condition. So, I mean, in sort of common planning parlance, we'd usually say this is the power to sort of amend conditions. Actually, legally, that's not quite how it works. But for the purpose of this discussion, we can take it as operating in that way. And so, what Clarkson's planning consultants proposed was to change the wording of the condition to make the rather than saying local producers being within the local authority boundary in this NB, to specifically say in the condition that it was within a defined radius of the premises. So they proposed, I think, 30 miles, but the local planning authority actually settled on 16 miles. And I think the reason for that, or certainly sort of infer from reading some of the documents, that's because the sort of furthest boundary from local authority boundary from the site was about 16 miles away. So I think that's where they'd come to the distance of 16 miles. I mean, to a certain extent, strikes me that that's arbitrary, but it's sort of it is understandable, I guess, from the perspective of the local planning authority that they'd want the ingredients to be sourced within their own boundary.
And of course, this all came to light. The reason it became an issue on the programme was because the enforcement officer happened to be in the Diddley Squat farm shop, or a planning officer was in the Diddley Squat farm shop and couldn't help but notice they were selling pineapples. And Cotswolds are not known for its pineapple growing by any stretch. So I guess one way or the other, the pineapples are no longer for sale, I presume, in the Diddley Squat farm shop. But I think that sort of, it was the MB, wasn't it, as you say, that there was a condition and then there was a sort of note after it. And there's an issue there. Is that part of the condition? Is it or not? And how do you read that? It's sort of warning to people, if you are, and I think a well-drafted condition can often include sort of defined terms, but you need to be very clear as to making sure that your definition is part of the condition, and not something extraneous to it, which I think was the risk here. But it'd be interesting moving forward. It seems to me there's a whole. Sorry, I was just going to say there's a whole season 2, Ian, on actually. Okay, we've got our 16 our 16-mile boundary now, but what if the field is within 16 miles, but the farm itself is just outside the 16 miles? Where is that produce from the 16 miles or not? So I think there's a whole season 2 that Clarkson can go with, I'm sure, on whether that condition is sufficiently clear.
Yeah, looking forward to it, Trevor. I mean, it must be honest, I hadn't watched that programme until I was made aware that there's some planning issues in it. So I'm all over it now.
Well, look, we probably ought to move on from Clarkson's farm. Let's get back to some proper law. I think I want to come on and talk about conditions precedent, but actually, if we can just go back briefly, because we've had a question come in as we've been speaking around the point about Section 106s and how you secure those by condition. And the question is effectively saying, if you have a condition that requires a 106, what effect does that have on the status of the planning permission? So Ian or Amy, do either of you have a view on that?
So Amy's got her hand up.
Go on, Amy. That's very polite.
No, sorry, I was just
You
reading the I don't know how I did that. I was just reading the question in the chat. I would assume that the condition required it to be entered into before development began, in which case I suppose this does sort of relate to the conditions precedent point, that you would need to make sure that you'd entered into it before you then began your development, or at least before the date at which you had to begin your development. It's my simple.
I think that's right.
I mean, I think that's right, isn't it? You know, I think it's this is a sort of standard granting condition. I mean, it's been considered, as Trevor mentioned earlier, I think by the courts before, and I mean, I can see that there's a further question.
There's a clarification of the question.
There's a clarification. Make sure we answer the right question.
Go on, keep going. So I think the clarification is: does it mean that the planning permission would remain in draft pending the 106 being completed? But
no, I don't think so. I mean, I think yeah, and I think that possibly what the question has got in mind is probably the distinction between a resolution to grant planning permission subject to a Section 106 agreement. So in that sort of situation, what the council is saying is that it would grant planning permission provided that a Section 106 agreement is first signed. And in that case, the planning permission would remain in draft. That's right. But there wouldn't be a planning condition that dealt with 106 in that sort of context. The sort of situation that we are talking about is so to sort of avoid any delay in the issue of the planning permission, we would have a condition that specifically said, do not start the development until all parts of the site are bound by a 106 agreement. And sometimes, certainly seen it in other contexts. I mean, sometimes you get a position where the developer perhaps doesn't own all of the site at the point that the planning permission is issued, and so it can sign a 106 agreement in relation to part of the site, but maybe not the rest. And again, to sort of avoid any delay in issuing the permission, what we can do is we can have a condition in that sort of form that says don't commence the development until all of the site is bound. And often we'll have a sort of a draft Section 106 agreement attached to the permission. So it's I suppose it's sort of in a way a bit innovative, and I know I've certainly had a bit of resistance in the past from local authorities who feel a bit nervous about that sort of condition. But it doesn't mean that that the permission is in draft. It just means that you can't commence your development until you've signed up to your 106 agreement.
I think that I've seen it in a number of circumstances. You see it quite a bit, I think, in compulsory purchase, where you have that slight chicken and egg, don't you? Where you need to have planning certainty in order to get your CPO, but you can't sign a 106 until you own the land, and you can't do that till you CPO'd. So you sort of see it there as well as perhaps in other contexts. But I think one of the key things, if you are doing it, you need to be very careful about wording, because you need to make sure that the condition is sufficiently certain as to what the 106 is going to say. And Ian, you made the point, actually having a draft of the 106 is probably the best way to do it. But at the very least, it needs to be very clear on what the terms are, because ultimately, in terms of trying to enforce that condition, you can only require the 106 to do what the condition clearly requires. So if you don't have all the planning obligations in there, you're going to be unable to reintroduce those matters back in. So it does take some very careful drafting, but it can be done. We've had a thank you for the questions. We've obviously answered the point. So let's go on to conditions precedent, pre-commencement conditions as they're known to their friends. And I said earlier that perhaps planning conditions get ignored. The ones that don't, I would suggest, are pre-commencement conditions. And there are very good reasons for that, in that if you don't get those discharged in good time, then there are some quite severe consequences potentially for landowners, aren't there? And so, Amy, I think this is very much about the Whitley principle, and then you can't talk about the Whitley principle in this context without also talking about sort of the Henry Boot exception and the implications of the Hart aggregates case. So can you just sort of set the scene for us with a brief sort of idiot's guide, if you like, for my benefit, please, to sort of Whitley and Henry Boot and Hart, please?
I can. So Whitley relates to conditions that require something to be done before development commences. If your operations, if you do something that contravenes that, so you commence development without having complied with whatever the condition required you to do before you commenced, you would be breaching planning control, and therefore those actions that you'd undertaken would be unlawful. So the biggest issue is on implementation. So if you've got a deadline to implement your permission and you haven't done it lawfully because you've done it in breach of a conditions precedent, that's a problem. You may well have lost your permission. So, but there are some exceptions to when it might be okay. So if you've done the actions in breach, but then you managed to get approval for whatever it was you needed to get approval for under the condition prior to the date when you had to implement, you've got a chance of righting that wrong. So you just have to keep in mind your deadline for implementation on that. The Henry Boot case, that looked at whether local authorities can waive condition that you haven't complied with. They can't. So you would have to either discharge the condition or vary it pursuant to Section 73. They can't do anything outside of that. And then Hart aggregates, which Trevor mentioned, looked at the conditions precedent themselves. And it's only the conditions that go to the heart of the permission, which are caught by this Whitley principle, pursuant to Hart aggregates case. So this made a distinction between conditions which require something to be done and conditions which expressly prohibit development taking place before you've met the requirements of the permission. So it's those latter ones that are really important that you comply with those, the ones that say you can't develop until you've done it. That's my whistle stop tour.
Thank you. And it's one that comes up all the time, doesn't it? When you're trying to establish whether a planning permission has been lawfully implemented, it's one of the first questions any planning lawyer will ask is, are the precons all discharged, and when were the precons discharged? Were they discharged in time? But I think, kind of for me, Hart aggregates in many ways should have been sort of helpful to developers, in that it was sort of reducing the pool of pre-commencement conditions that might, if they're not discharged in time, lead to the permission lapsing. But I think as a lawyer, the challenge has always been this sort of slightly nebulous concept of, does it go to the heart of the permission or not? And certainly for me, I've always been a little uncomfortable in advising on whether something does or doesn't, and ultimately err on the side of caution, just get everything that might be a pre-commencement condition discharged and don't take the risk. But I think Ian, we've had a case on this very point recently, and with the Maisel case, which was looking at how do you begin to decide whether something goes to the heart of the permission or not. Tell us a little bit more about what that case said, please.
Yeah, so I mean, as you say, I mean, I think this is, this is quite a tricky issue, and I would say this is probably one of the top sort of things that we're asked to advise on. I mean, it comes up in lots of different contexts, quite frequently in due diligence, actually. But I mean, I've been involved in several enforcement cases that have sort of engaged with these principles, and as you say, the Hart aggregates case, I think. I mean, there are a number of cases on this. Obviously, the Whitley principle would result in sort of really harsh outcomes in a lot of cases. And so I think what the court in Hart aggregates is trying to do is sort of soften that, and by suggesting this test of whether the condition goes to the heart of the permission. But I mean, it's not entirely unproblematic, as you say, because it is often quite difficult to sort of make a judgment on these sort of things. In this particular case, as you say, I think it might be called Meisels actually rather than Maisel, but I don't know. This was an enforcement notice case that related to a synagogue, and the condition in question was a condition relating to the approval of materials. Effectively, what the court said is, when we're looking at this question, it's very fact sensitive one, so we have to really look at the circumstances of the particular case. There are no general rules that we can really apply to this. Effectively, what the court's saying is that this is a sort of classic matter of planning judgment, and the court would only interfere with that in the event that that the inspector's or the local planning authority's judgment is unreasonable. Now, in that case, I would have thought that certainly without reading the case, I think approval of materials would strike me as something that does go to the heart of a permission, because it relates obviously very strongly to what the particular development looks like, and that's what the inspector found in this case. The court effectively said that the judgment of the inspector was unimpeachable, and they wouldn't interfere. The more difficult cases, though, I think, Trevor, are ones that don't, are not clearly on one side of the line or another. And I had a case a few years ago that related to the requirement to have an archaeological survey program approved prior to the commencement of development. And I mean, without going into all the sort of the particular facts of that case, it was quite difficult because it was a sort of a general condition, if I can put it that way. It didn't go to any, it was something that was applied to any permission that was issued in this particular area, and it was nothing to do with the sort of specifics of this case. Actually, there was another court case at the same time where the High Court found that that particular condition, it was almost exactly the same words as the one I was considering, didn't go to the heart of the permission. So that's the sort of situation where the courts have found that sort of pre-commencement condition didn't go to the heart of the permission, and so wasn't a sort of a true pre-commencement condition in the Whitley case, but in the Whitley sense rather. But it really is hard to advise clients, and the sort of the takeaway from this is to just be really careful around discharge of conditions, making sure that you have evidence of discharge before commencement. Because I've got to say, I think you've been quite optimistic there, Trevor, in saying that these are the ones that are always paid attention to. I mean, they get more attention, but I mean, just certainly whether I just attract these sort of cases, I don't know. But I mean, certainly in my experience, they are very often overlooked. And discussions I've had with other sort of professionals in the planning system, in the construction industry, suggest that not everyone takes them as seriously as they probably should do. So so that's pre-commencement conditions and Meisels.
It's a fair point, and I think that the court was right. I think in Meisels, sorry if it's Meisels or Measles, but the court was right, I think, to say it's planning judgment. There's not it's not a legal point, is it? Which is a pity, because if it was a legal point, we could put some tests around it and we could apply those tests and come up with the answer. But I think the fact it's planning judgment, your point, you can have two different decision makers come to different judgments. So I think the problem still remains that it's very difficult to, with any certainty, say in advance this is or is not. And so I think my advice still remains, if it looks like a pre-commencement condition and sounds like a pre-commencement condition, let's work on the basis it is and make sure you've got it discharged before the expiry of the permission in order to just avoid that risk. I suppose you could look at the certificate to get some certainty, but Otherwise, you are taking the risk that the planning authority or an inspector will ultimately agree with you that it is not dealing with a matter that goes to the heart of the particular permission you're dealing with, aren't you?
Yeah, I mean, you never want to find yourself at the mercy of a planning inspector, do you, in these sort of situations? I mean, interestingly, the context that I've often come across this is where, situations where the council has granted planning permission for something and actually later on sort of almost changes its mind, if you like. So, you shouldn't take the view that, well, the council's granted planning permission for this development, so, it's going to take a sort of benevolent view, as Amy was saying earlier on, Amy's phrase, wasn't it? It's going to take a benevolent view here. Councils do, can and do take enforcement action in those situations. And, the particular case I was talking about just now with the archaeological survey condition, that's effectively what had happened. There'd been a change in leadership at the council. The council's ideas about the development of that area have changed quite a bit. And, effectively what the council were doing, certainly in my view, was, sort of seizing on an opportunity to try and get rid of a permission that they wish they hadn't issued. So, it is quite a serious situation. And, as you say, Trevor, I think, you need to make sure that you've dotted all your I's, crossed all your T's, and don't leave yourself at the mercy of the council's planning judgment or an inspector's planning judgment, as I say, because they, it's not guaranteed that they'll agree with you.
Quite. I'm conscious of time. We've got about 3 minutes left, and we always try to make sure we stick within the hour. Normally, at around about this point, I would talk about legislation that's come through in the last month. The good news is there isn't any, so I haven't got to squeeze that in. So in the last, what's probably now 2 minutes, just 30 seconds perhaps from each of you on what is the practical takeaway that people should take away from today's session. Amy, can I come to you first?
I think whilst I've talked about benevolence in interpreting planning conditions, the best thing is to check up front that they are sensible and are making sense, and that they say what you want them to say without having to imply any words into them.
Wise words. Ian, any more wise words from you?
Yeah, I think it's the pre-commencement conditions point that we were just talking about. So I won't go on about it again, but I am passionate about it, as you can tell.
Fair enough. It makes due diligence so much easier if everyone's got them discharged in the timely way, doesn't it? Okay, well, look, we are right up on the hour now, so I will close this on time. But if I can just thank you, Amy and Ian, for coming along today. If I can thank our audience, and I hope you found it interesting. If you do have questions, please do feel free to reach out to any of us, or indeed any member of the DLA Piper team. We'll happily talk through any issues with you. But otherwise, thank you again for being with us, and I hope you'll join us for the November edition of Outline next month. Thank you and goodbye.